Rylands v Fletcher, 1868, UKHL 1 was a decision by the House of Lords which established a new area of English tort law. Rylands employed contractors to build a reservoir, playing no active role in its construction. When the contractors discovered a series of old coal shafts improperly filled with debris, they chose to continue work rather than properly blocking them up. The result was that on December 11, 1860, shortly after being filled for the first time, Rylands' reservoir burst and flooded a neighbouring mine, run by Fletcher, causing £937 worth of damage. Fletcher brought a claim under negligence, through which the case eventually went to the Exchequer of Pleas. The majority ruled in favour of Rylands. However, Bramwell B, dissenting, argued that the claimant had the right to enjoy his land free of interference from water, and that as a result the defendant was guilty of trespass and the commissioning of a nuisance. Bramwell's argument was affirmed, both by the Court of Exchequer Chamber and the House of Lords, leading to the development of the rule in Rylands v Fletcher. That the person who for his own purposes brings on his lands and collects and keeps there anything likely to do mischief if it escapes, must keep it in at his peril, and, if he does not do so, is prima facie answerable for all the damage which is the natural consequence of its escape. No right to enjoy property exists in UK black-letter law, and it is this decision upon which stare decisis is built in the area. This doctrine was further developed by English courts, and made an immediate impact on the law. Prior to Rylands, English courts had not based their decisions in similar cases on strict liability, and had focused on the intention behind the actions rather than the nature of the actions themselves. In contrast, Rylands imposed strict liability on those found detrimental in such a fashion without having to prove a duty of care or negligence, which brought the law into line with that relating to public reservoirs and marked a significant doctrinal shift. Academics have criticized it, however, both for the economic damage such a doctrine could cause and for its limited applicability. The tort of Rylands v Fletcher has been disclaimed in various jurisdictions, including Scotland, where it was described as a heresy that ought to be extirpated, and Australia, where the High Court chose to destroy the doctrine in Burney Port Authority v General Jones Proprietary Limited. Within England and Wales, however, Rylands remains valid law, although the decisions in Cambridge Water Company Limited v Eastern Countries Lever plc and Transco plc v Stockport Metropolitan Borough Council make it clear that it is no longer an independent tort, but instead a sub-tort of nuisance. Facts: in 1860, John Rylands paid contractors to build a reservoir on his land, intending that it should supply the Ainsworth Mill with water. Rylands played no active role in the construction, instead contracting out to a competent engineer. While building it, the contractors discovered a series of old coal shafts and passages under the land filled loosely with soil and debris, which joined up with Thomas Fletcher's adjoining mine. Rather than blocking these shafts up, the contractors left them. On December 11, 1860, shortly after being filled for the first time, Rylands' reservoir burst and flooded Fletcher's mine, the Red House Colliery, causing £937 worth of damage. Fletcher pumped the water out, but on April 17, 1861 his pump burst, and the mine again began to flood. At this point a mines inspector was brought in, and the sunken coal shafts were discovered. Fletcher brought a claim against John Rylands, the owner, and Joel Horrocks, the manager of Rylands' reservoir on November 4, 1861. Judgment. Liverpool Assizes the tort of trespass was inapplicable, as the flooding was deemed not to be direct and immediate. The tort of nuisance was rejected as this was a one-off event. The case was first heard by Mellor J. and a special jury in September 1862 at the Liverpool Assizes. A court order led to an arbitrator from the Exchequer of Pleas being appointed in December 1864. The arbitrator decided that the contractors were liable for negligence, since they had known about the old mine shafts. Rylands, however, had no way of knowing about the mine shafts and so was not. Exchequer of Pleas the case then went to the Exchequer of Pleas, where it was heard between 3rd and 5th May 1865. It was heard on 2 points. Firstly, whether the defendants were liable for the actions of the contractors, and secondly, whether the defendants were liable for the damage regardless of their lack of negligence. They decided for the first point that the defendants were not liable, but more split on the second point. Pollock C.B., Martin B. and Channel B. held that the defendants were not liable, as since a negligence claim could not be brought there was no valid case. Bramwell B., dissenting, argued that the claimant had the right to enjoy his land free of interference from water, and that as a result the defendant was guilty of trespass and the commissioning of a nuisance. He stated that the general law in matters wholly independent of contract should be that the defendants were liable, on the plain ground that the defendants have caused water to flow into the claimant's mines, which but for the Defendants Act would not have gone there. Plus. Court of Exchequer Chamber Fletcher appealed to the Exchequer Chamber of 6 judges. The prior decision was overturned in favour of the appellant Fletcher. Blackburn J. spoke on behalf of all the judges and said that, Blackburn J.'s opinion relied on the liability for damages to land available through the tort of chattel trespass and the tort of nuisance, as well as the in si interaction, injury by a domesticated animal known to have a disposition to injure. Rylands appealed. House of Lords The House of Lords dismissed the appeal and agreed with the determination for Fletcher. Lord Cairns, in speaking for the House of Lords, stated their agreement of the rules stated above by Justice Blackburn, but added a further limitation on liability, which is that the land from which the escape occurs must have been modified in a way which would be considered non-natural, unusual or inappropriate. The case was then heard by the House of Lords on 6 and 7 July 1868, with a judgment delivered on July 17. Oddly, the court consisted of only 2 judges, Lord Cairns and Lord Cranworth. Lord Colonsay failed to attend. The eventual judgment confirmed Blackburn's decision and general principle, adding a requirement that the use be non-natural. The judgment of Lord Cairns LC was as follows. Significance. Enjoyment of property the enjoyment of land was primary in the reasons of Lord Cairns. This foundation stone is a recurring theme in the common law throughout the ages, to wit, it has been well said, that the use of the law consists, first, in preserving men's persons from death and violence. Next, in securing to them the free enjoyment of their property. Tyndall, C.J., charged to the grand jury at Bristol on the occasion of the 1832 riots over the rejection in the House of Lords of the Reform Bill. Change to the law early English common law had, in many instances, imposed liability on those who had caused harm regardless of wrongful intent or negligence. Trespass was considered a remedy for all tortious wrongs, and sometimes used as a synonym for torts generally. Over the centuries, however, judges focused more on the intent and negligence behind the actions than the nature of the actions themselves, leading to the development of negligence and nuisance and the further development of trespass. At the time of Rylands, the previous case relied upon was Vaughan v. Menlove, decided in the Court of Common Pleas in 1837. The case had almost identical facts to Rylands, but strict liability was never even considered. The case is instead thought of as one of the best attempts of early 19th-century English judges to build up the law of negligence. The outcome of Rylands meant that judges would again impose strict liability on defendants who accumulated dangerous things on their land without any need to prove negligence or wrongful intent. The decision won support for bringing the law relating to private reservoirs up to standard with the law relating to public reservoirs, which contained similar statutory provisions thanks to a pair of private Acts of Parliament passed in 1853 and 1864. Assessment The decision in Rylands initially faced little criticism within England and Wales, although many American scholars and judges of the time felt that judgment was a poor one. Doe C.J. of the New Hampshire Supreme Court wrote that it put a clog upon natural and reasonably necessary uses of matter and tend to embarrass and obstruct much of the work which it seems to be a man's duty carefully to do. The American interpretation was based primarily on the idea that it would cause economic harm. Further American criticism is based on the idea that it is poor law. Firstly, they argue, it is not trespass, since the damage is not direct, and secondly, it is not a nuisance, because there is no continuous action. Glofchesky, writing in the Hong Kong Law Journal, notes that the doctrine has not flourished. a tort imposing strict liability should be closely interpreted and circumspectly applied. It has been argued that the decision was never entirely accepted by the judiciary as a whole, and that it is difficult to justify. This is for two reasons. Firstly, it is a case of very limited applicability, and it has been suggested that it be folded into a general principle of strict liability for ultra-hazardous activities. Secondly, subsequent case law in England and Wales, particularly in Rickards v Lothian, has undermined the non-natural use element by introducing a cost-benefit analysis which severely limits the decision's usefulness. Canada equals. The first article in the 1960 Canadian Bill of Rights states that the right of the individual to life, liberty, security of the person and enjoyment of property, and the right not to be deprived thereof except by due process of law is recognized. However, it is difficult to adjudicate on this bill, especially as the provinces have priority over property rights. A difficulty is encountered with the definition of property, as remarked by Johansson, which may well be the reason why the matter remains for interpretation by precedent. The 1974 test case for the Bill of Rights, Attorney General of Canada v. Laville, provided an impetus for the 1982 Charter of Rights, which specifically excludes the enjoyment of property for reasons described in the Constitutional History of Canada page. Friedman on torts in Canada has helpful material. In Ontario, a common law province, Rylands was upheld by a lower court in Smith v. Inco Limited. A case alleging that a factory in Port Colborne, Ontario had contaminated adjacent lands with nickel. A subsequent Ontario Court of Appeal ruling in 2010 found that the plaintiff had not provided sufficient evidence of economic harm, raising the legal burden of proof but not invalidating Rylands as precedent law. However, it has been said that the Court of Appeal erred in law in their adjudication over the words non-natural. In April 2012, the Supreme Court of Canada chose not to hear the appeal. Mineral rights in the subsurface seem to be preferred over the landowner's rights by the Mineral Tenure Act or the Petroleum and Natural Gas Act in British Columbia, so that recourse to Rylands is quite limited, as case law has developed over liability to compensate the owner of a surface area for loss or damage caused by the entry, occupation or use of that area, and compensation for nuisance and disturbance from the entry, occupation or use. The compensation for entry, use and occupation of the property seems not to exceed the entire, taxable value of the land as written in the registry. This means in effect that the relocation costs or emotional damage are likely not payable by the expropriator. Even municipalities cannot exclude minors. The powers of an arbitrator include compensation for land, timber and time, but expressly do not include watershed, health and welfare, or lost cattle. Minors avoid environmental review. The province has no discretion to refuse mineral leases. Minors need not notify landowners of transactions. The province can exempt mines from review when mining commences. And landowners do not have rights to refuse to negotiate. The impact of Rylands v Fletcher in Quebec law, which is based for historical reasons on the Civil Code, was evaluated by the Supreme Court of Canada in the 1916 case of Vaudreuil v. Quebec Railway, Light, Heat and Power Company. The SCC found that a section in the Civil Code had ample scope to support the liability of the Quebec Power Company. England and Wales equals. Developments. The party that can be sued in a Rylands claim is an owner or occupier of land, along with anyone who stores or collects the dangerous material, as in Rainham Chemical Works Limited v Belvedere Fish Guano Company Limited. The party suing was initially one with an interest in land, but Perry v Kendricks Transport Limited confirmed that an interest in land was not necessary to bring a claim. Historically, personal injury claims have been allowed, as in Hale v Jennings. More recent cases, however, such as the House of Lords decision in Transco plc v Stockport Metropolitan Borough Council, have confirmed that Rylands is a remedy for damage to land or interests in land. It must follow that damages for personal injuries are not recoverable under the rule. In Cambridge Water Lord Gough opined that the rule in Rylands should not further be developed, and that rather than being an independent tort it should be instead considered a sub-tort of nuisance. Statutory provisions. such as the Environmental Protection Act 1990, were a more modern and appropriate way of addressing environmental problems which would previously have been covered by Rylands. Subsequently, Transco disapproved of the Australian decision in Burnie Port Authority v General Jones Proprietary Limited to absorb Rylands into the general law of negligence, deciding that Rylands should continue to exist but, as Lord Bingham said, as a subspecies of nuisance, while insisting upon its essential nature and purpose, and restate it so as to achieve as much certainty and clarity as is attainable. It is now a sub-tort, rather than an independent tort. They have confirmed that it will be allowed to remain. Donald Nolan has argued that to consider Rylands as part of private nuisance is unsound. Private nuisance requires the claimant to have an interest in land, while Rylands does not. Although exceptions to this rule have occasionally been made in private nuisance, in Hunter v Canary Wharf Limited, the House of Lords ruled that to make exceptions would transform nuisance from a tort against land to a tort against a person, and should not be permitted. John Murphy, Professor of Common Law at the University of Manchester, agrees with Nolan, and makes the additional point that nuisance is focused on a loss of enjoyment to land, not physical damage as Rylands is. It has also been concerned that the reasonable use test, which appears in nuisance, is not applicable to cases brought under Rylands. Brings, collects and keeps. The first requirement under Rylands is that the defendant for his own purposes brings onto land and collects and keeps there. In Rylands, this was the keeping of water in a reservoir. Other cases in England and Wales have illustrated what sort of material is considered. In British Celanese v. Hunt, the accumulation was of metal foil strips. For his own purpose is not understood to be for his benefit, although that was what Blackburn was referring to at the time. In Smeaton v. Ilford Corporation, Rylands was held to apply to a local authority accumulating sewage on its land, although there was no benefit to the local authority from doing this. Mischief and escape. The next element of Rylands is that the thing be something likely to do mischief if it escapes. Before Transco plc v Stockport Metropolitan Borough Council, this did not have to be a dangerous item. The risk was instead in its behaviour if it escapes. In Rylands the thing was water. Other examples are fire, as in Jones v Festiniog Railway, gas, as in Batchelor v Tunbridge Wells Gas Company, fumes, as in West v Bristol Tramways Company, and electricity, as in Hillier v Air Ministry. The extent of the thing's accumulation can also be considered, as in Mason v Levy, where it was not just the type of thing kept but the sheer amount which created the danger. It is essential for a Rylands claim that there be an escape of a dangerous thing from a place where the defendant has occupation of or control over land to a place which is outside his occupation or control. In Reed v J. Leon and Company Limited, an explosion in a munitions factory killed an inspector on the property. Rylands was held not to apply, because there was no escape. The dangerous thing that escapes does not always have to be the thing which was accumulated, but there must be a causal link. In Miles v Forest Rock Granite Company Limited, explosives stored on the defendant's land led to the escape of rocks in a blast, and the defendant was found liable. In Transco plc v Stockport Metropolitan Borough Council, Lord Bingham stated abitely that I do not think the mischief or danger test should be at all easily satisfied. It must be shown that the defendant has done something which he recognised, or judged by the standards appropriate at the relevant place and time, he ought reasonably to have recognised, as giving rise to an exceptionally high risk of danger or mischief if there should be an escape, however unlikely an escape may have been thought to be. Non-natural use. The requirement of non-natural use, which was created when the case went to the House of Lords, was described by Lord Moulton, in Rickards v Lothian, as some special use bringing with it increased danger to others. Because the idea of something being non-natural is a subjective one, the interpretation of this principle has varied over the years. In Musgrove v Pandelis, a car filled with petrol was considered non-natural, while in Rainham Chemical Works Limited v Belvedere Fish Guano Company Limited, so was the operation of a munitions factory during wartime. There is no single concrete test to define what is non-natural, for reasons given by Lord Bingham and Transco plc v Stockport Metropolitan Borough Council. Non-natural use is not a test to be inflexibly applied. A use may be extraordinary and unusual at one time or in one place but not so at another time or in another place. I also doubt whether a test of reasonable user is helpful, since a user may well be quite out of the ordinary but not unreasonable. Defences. There are several defences in England and Wales to a claim under Rylands v Fletcher. Act of an unknown third party, contributory negligence, consent and statutory authority. An act of an unknown third party will absolve the defendant of liability, as in Perry v Kendricks Transport Limited. In Northwestern Utilities Limited v London Guarantee and Accident Company Limited, the principle was established that if a claimant knows of the unknown third party and their actions, the defendant is additionally likely to be able to deny liability. As Rylands requires strict liability, any contributory negligence voids most of the claim. Initially it was sufficient to offset the case itself. With the Law Reform Act 1945, courts instead apportion damages, taking into account how much of the harm was contributed by the claimant. Nevertheless, contributory negligence is still a viable partial defense to a Rylands claim. Other valid defenses are where the claimant has consented, expressly or impliedly, to the accumulation of the thing, and where there is statutory authority for the accumulation. Scotland the principles of Rylands v Fletcher were initially applied in Scots law, first in the case of Mackintosh v Mackintosh, where a fire spreading from the defendant's land to the claimant's land caused property damage. Scots lawyers and judges applied Rylands differently from their English counterparts, however. While the rule is interpreted in England and Wales as being distinct from negligence and the rules of duty of care and liability applied there, the principle in Scotland was that negligence is still the ground of liability. The only difference is that in such cases the proprietor is doing something upon his property which is in its nature dangerous and not necessary in the ordinary management of the particular kind of property, and he is therefore bound to observe a higher degree of diligence to prevent injury to his neighbour. The use of Rylands in Scots law, which was started in Mackintosh, finally came to an end in H. M. Baker v Strathclyde Regional Council. Lord Fraser, as part of his judgment, stated that the idea of strict liability that was brought into play by Rylands was not a part of Scots law, and the idea that it ever had been valid was a heresy that ought to be extirpated. United States Within the United States, there are many situations in which strict liability is applied to actions, and Rylands is commonly cited as the origin of that rule. It was first applied in Ball v. Nye, by the Supreme Court of Massachusetts. The Supreme Court of Minnesota also adopted it in Cale v. Eastman, while the Supreme Courts of New York, New Hampshire and New Jersey all rejected the principle, in Lucy v. Buchanan, Brown v. Collins, and Marshall v. Wellwood respectively. The Supreme Court of New Jersey, however, reversed Wellwood in 1983 in Department of Environmental Protection v. Ventron Corporation. Many courts in the United States have attempted to use Rylands to justify absolute liability, which it was never intended to do. While absolute liability is where no defense is applicable, in Rylands itself Lord Cairns accepted that there were some situations where the case should not be applied. Australia In Australia, the principles of Rylands v Fletcher were killed off by the High Court of Australia in Burnie Port Authority v General Jones Proprietary Limited. The High Court's view was that the Rylands principles should now been seen as absorbed by the principles of ordinary negligence, and not as an independent principle of strict liability. Contrasting this, the principles have escaped destruction in Hong Kong, where the courts are yet to follow the examples set by Australia and England and Wales, and Rylands remains an independent tort. See also, English tort law, U.S. tort law, strict liability, Lake Pugner. Notes. References, Birmingham, Vera. Carol Brennan. Tort law. Oxford University Press. ISBN 978-0-19-927998-3. Bollen, Francis H. The Rule in Rylands v. Fletcher. Part 1. University of Pennsylvania Law Review and American Law Register 59. ISSN 0041-9907. Cameron, Gordon. Scots and English Nuisance. Much the same thing? Edinburgh Law Review 9. ISSN 1364-9809. Cameron, Gordon. Making Sense of Nuisance in Scots Law. Northern Ireland Legal Quarterly 56. ISSN 0029-3105. Kane, Peter. The Changing Fortunes of Rylands v. Fletcher. University of Western Australia Law Review 24. ISSN 0042-0328. Elliott, Catherine. Francis Quinn. Tort Law. Pearson Longman. ISBN 978-1-4058-4672-1. Fordham, Margaret. Surviving Against the Odds, The Rule in Rylands v. Fletcher Lives On. Singapore Journal of Legal Studies. ISSN 0218-2173. Glovchesky, Richard. Reasonable Foreseeability, Pollution and the Rule in Rylands v. Fletcher. Hong Kong Law Journal 24. ISSN 0378-0600. RF v. Houston and R.A. Buckley, The Return of Rylands v. Fletcher 110 LQ of 506-509, RF v. Houston, who was the third Lord in Rylands v. Fletcher. 86 LQ of 160, Murphy, John. The Merits of Rylands v. Fletcher. Oxford Journal of Legal Studies 24. ISSN 0143-6503. Nolan, Donald. The Distinctiveness of Rylands v. Fletcher. Law Quarterly Review 121. ISSN 0023-933X. Simpson, A.W.B. Legal Liability for Bursting Reservoirs, The Historical Context of Rylands v. Fletcher. The Journal of Legal Studies 13. ISSN 0047-2530. Waite, A.J. Deconstructing the Rule in Rylands v. Fletcher. Journal of Environmental Law 18. ISSN 0952-8873. Woodside 3, Frank C. Mark L. Silbersack. Travis L. Fleeman. Douglas J. Feichtner. Why Absolute Liability under Rylands v. Fletcher is Absolutely Wrong. Dayton Law Review 29. ISSN 0162-9174. External links, full text of judgment on Baylor.